Hi everybody, it's Andy and welcome again to my office in Modesto, California. I'm an attorney licensed to practice law in California as well as New York. In this video we're going to go over the California answer to this question. Andy, I've signed my will, my trust, my prenup, my power of attorney. Don't I need to file that with the court in order to make it legally valid, in order to make it effective? And it's a very understandable question, basically, don't I need to file X document with the court or with somebody in order to make it valid? Me simply signing it, that's not enough, right? Now, the general answer, the completely true technical answer is it depends. Sorry, it really does. It depends on the type of document that you're talking about. However, there are quite a few documents, at least in California, that do not require filing with the court or filing with any type of governmental agency in order to become valid. For example, if you have a prenuptial agreement, you're about to get married, or maybe you are married and you filled out a post-nup or something. If you have any type of nuptial agreement about what happens when the marriage ends, does that need to be filed with the court? And in general, the answer is no. Not until you actually have a divorce or something, in which case maybe you guys are fighting about what the prenup means or something. But the idea then basically is that you and your spouse will fill out the prenup, you'll sign it, you'll each keep a copy of it, and then years go by, months go by, decades go by, whatever. And if you guys actually do need the prenup because you end up splitting up or something, in that case, out comes the prenup, and then it becomes useful. Hopefully, the prenups are signed, filled out, and stuff. Each person keeps a copy, and that's the last that you hear of the prenup. The happy couple lives happily ever after. That's one example. So for prenups, at least, it's a very common question. Do I need to file my prenup with the court right after I sign it in order for it to become valid? And the answer is no. Aside from the explanation that I just gave, there's also a practical reason here too. Courts are not going to keep a copy of your prenup in a file somewhere just in case you maybe need it one day, just in case maybe you and your spouse do get divorced. Courts simply don't have the room, they don't have the resources to do that. They're basically the burden of keeping a prenup is going to be on you if and when you need it, then bring it out. In that case, then you might have to file it, like I said. So that same logic applies to other documents as well. So for example, a power of attorney, do you need to file that with the court? No. You can record it with the county, but that's not something that most people do. Most people just fill out the power of attorney form, sign it, get a witness, notarize, whatever, and then that's basically it. That's the it's valid from then on. Other common documents that I see, wills. Once you sign a will, do you need to actually have it filed with the court? No. Wills are filed with the court during the probate process. However, the person who has made the will has already passed away. So wills are filed with the court eventually, but it's not right away. You don't have to make your will, file it with the court in order for it to be valid. Once a will is executed properly in California, that's it. And the execution does not require filing it with the court. What else? Powers of attorney, I said, a lot of times people will wonder, don't I need to file that with the court? No. Wills, no, until the person has passed away. Living trusts, no. You basically sign the papers, sign the living trust document, get it notarized, etc., and that's basically it. You can record stuff, and hopefully as time goes on, if I get the time, I will make a video about recording documents as well. Hopefully I'll link that right over here. But if you own a house or property or something in California, this is basically the county recorder's office where deeds and other kind of things like that are recorded. So there's a whole humongous category of documents that people think need to get filed with the court or done something with the court, filed, signed, endorsed, whatever, in order to become valid, and the answer is basically no. You don't need to sign it or to file it with the court in order for it to become valid. It's valid upon signature. So that's a very general answer. However, there's a lot of kind of nuance, exception to what I just described. My whole point in this video is basically to tell you that there are a large category of documents, more than the average person would think, that become valid, legally enforceable, I guess, upon signing. There's no filing or recording kind of requirement that has to get done. There are, however, some documents that are not that way. There are some documents that do need to get filed with the court, that do need to get recorded in order to become valid. But the number of those documents that filing and recording is required for is much smaller than most people think. So hopefully that helps. Because this area can be complicated, I would highly recommend consulting a professional advisor, I guess, a lawyer, somebody with experience in this area. If you're kind of wondering or you're on the fence about whether or not your document has to get filed or recorded in order to be valid. So hopefully that helps. If this was a little confusing, I tried not to make it that way. But go ahead and rewatch this video if you want. Leave me a comment if you have any questions, and I will talk to you next time. Thanks.